La Cour.
Please be seated. Sitting is open. The court meets this morning under Article 74, Paragraph 3 of the Rules of Court, to hear the oral argument of Ukraine on its request for the indication of provisional measures submitted in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus the Russian Federation. Certified copies of the application and the request for the indication of provisional measures submitted by Ukraine on 26 February 2022 were immediately transmitted to the government of the Russian Federation, and further communications were sent with details of the current hearings. By a letter dated 5 March 2022, His Excellency Mr. Alexander V. Shulgin, Ambassador of the Russian Federation to the Kingdom of the Netherlands, indicated that his government did not intend to participate in the oral proceedings. The Court regrets the non-appearance of the Russian Federation in these oral proceedings. In this regard, I note that in accordance with the Rules of Court, the specific dates for these oral proceedings were set in light of the urgency of the request for provisional measures and in order to enable the respondent to be represented at the hearing. Pursuant to Article 59, Paragraph 2 of its rules, the Court may decide for health, security, or other compelling reasons to hold a hearing entirely or in part by video link. Owing to the ongoing concerns related to the COVID-19 pandemic, the Court has decided to hold these oral proceedings in a hybrid format. The Court has taken great care to ensure the smooth conduct of this hybrid hearing. Ukraine participated in technical tests prior to the opening of the hearing. These tests were comprehensive and included, for example, tests of the interpretation system and the process for displaying exhibits. However, while these tests reduce the risk of technical difficulties, they cannot eliminate them. In the event that we experience any such difficulty, such as a loss of any audio input from a remote participant, I may have to interrupt the hearing briefly to allow the technical team to solve the problem. In a hybrid hearing such as this one, all judges are able to view the speaker and any demonstrative exhibits, regardless of whether they are in the Great Hall or joining via video link. I would like to note that the following judges are present with me in the Great Hall of Justice: Vice President Gevorgian, Judges Tomka, Abraham, Shui, Sebutinde, Iwasawa, Nolte, and Charlesworth, and Judge Ad hoc Dode, while Judges Benuna, Yusuf, Bandari, Robinson, and Salam are participating by video link. For reasons duly made known to me, Judge Cansado Trindade is unable to sit with us in these oral proceedings, either by person or by video link. For this hybrid hearing, the registrar informed both parties that each of them could have up to 5 representatives present at the Great Hall of Justice at any one time, and that the court could make available, should a party so desire, an additional room in the Peace Palace from which other members of the delegation could follow the proceedings via video link, which would be available to members of each delegation who would not be present in the Peace Palace. Since there is no judge of Ukrainian nationality on the bench, Ukraine has availed itself of the right conferred upon it by Article 31, Paragraph 2 of the statute to choose a judge ad hoc, choosing Professor Yves Daudet. Article 20 of the statute provides that every member of the court shall, before taking up his duties, make a solemn declaration in open court that he will exercise his powers impartially and conscientiously. Pursuant to Article 31, paragraph 6 of the statute, the same provision applies to judges ad hoc. In accordance with custom, I shall first say a few words about the career and qualifications of Professor Daudet before inviting him to make his solemn declaration. Professor Yves Daudet, who is of French nationality, is a Doctor of Law and Professor, agrégé of Public International Law and Political Science. He is currently President of the Curatorium of the Hague Academy of International Law and Emeritus Professor at the University of Paris I, Panthéon-Sorbonne, where he served as the first Vice President. Professor Daudet is an arbitrator in the Court of Conciliation and Arbitration within the Organization for Security and Cooperation in Europe. He has held a number of academic and research positions in France, Mauritius, Morocco, and Côte d'Ivoire. He was a member of the French delegation to the United Nations Conference on the International Code of Conduct on the Transfer of Technology. He has been chosen as judge ad hoc on numerous occasions and is currently sitting in the case concerning dispute over the status and use of waters of the Salala, Chile versus Bolivia, the case concerning alleged violations of sovereign rights and maritime spaces in the Caribbean Sea, Nicaragua versus Colombia, and in the two cases concerning application of the International Convention on the Elimination of All Forms of Racial Discrimination, Armenia versus Azerbaijan, and Azerbaijan versus Armenia. Professor Daudet is a member of the editorial board of the Annuaire Français du Droit International and is a member of the French Society of International Law and the French branch of the International Law Association. He has published numerous books and articles in different areas of international law. I shall now invite Professor Daudet to make the solemn declaration prescribed by the statute, and I would request all those present to rise. Professor Daudet, you have the floor.
Merci.
Yes, thank you, Madam President. I solemnly declare that I fulfil my duties and exercise my attributions as judge, full honour and devotion, full and perfect impartiality and conscientiously. Thank you.
Mr. Daudet, please be seated. I take note of the solemn declaration made by Judge ad hoc Daudet and declare him duly installed as Judge ad hoc in the case concerning allegations of genocide under the Convention on the Prevention and Punishment of the Crime of Genocide, Ukraine versus Russian Federation. I shall now recall the principal steps of procedure in the present case. On 26 February 2022, Ukraine filed in the Registry of the Court an application instituting proceedings against the Russian Federation concerning, I quote, a dispute relating to the interpretation, application, and fulfillment of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, end of quote. I shall refer to this convention as the Genocide Convention. To found the jurisdiction of the court, Ukraine invokes Article 36, Paragraph 1 of the Statute of the Court and Article 9 of the Geneva Convention. In its application, Ukraine contends inter alia, and I quote, the Russian Federation has falsely claimed that acts of genocide have occurred in the Luhansk and Donetsk Oblast of Ukraine, and on that basis recognized the so-called Donetsk People's Republic and Luhansk People's Republic, and then declared and implemented a special military operation against Ukraine with the express purpose of preventing and punishing purported acts of genocide that have no basis in fact. On the basis of this false allegation, Russia is now engaged in a military invasion of Ukraine involving grave and widespread violations of the human rights of Ukrainian people. End of quote. Ukraine denies that any such genocide has occurred and states that it submitted the application, I quote, to establish that Russia has no lawful basis to take action in and against Ukraine for the purpose of preventing and punishing any purported genocide, end of quote. In its application, Ukraine also accuses the Russian Federation of carrying out the actus reus of genocide by intentionally killing and inflicting serious injury on Ukrainian nationals, accompanied by what Ukraine considers rhetoric suggestive of genocidal intent. Together with its application, Ukraine also submitted a request for the indication of provisional measures, referring to Article 41 of the statute and Articles 73, 74, and 75 of the Rules of Court. According to Ukraine, the purpose of its request is to, I quote, prevent irreparable prejudice to the rights of Ukraine and its peoples, and avoid aggravating or extending the dispute between the parties under the Genocide Convention, end of quote. The registrar will now read out the passage from the request specifying the provisional measures which the government of Ukraine is asking the court to indicate. You have the floor, Mr. Registrar.
Thank you, Madam President. I quote, Ukraine respectfully requests that the court indicate the following provisional measures. A. The Russian Federation shall immediately suspend the military operations commenced on 24 February 2022 that have as their stated purpose and objective the prevention and punishment of a claimed genocide in the Luhansk and Donetsk Oblast of Ukraine. B. The Russian Federation shall immediately ensure that any military or irregular armed units which may be directed or supported by it, as well as any organizations and persons which may be subject to its control, direction and influence, take no steps in furtherance of the military operation which have as their stated purpose and objective preventing or punishing Ukraine for committing genocide. C. The Russian Federation shall refrain from any action and shall provide assurances that no action is taken that may aggravate or extend the dispute that is the subject of this application or render this dispute more difficult to resolve. D. The Russian Federation shall provide a report to the court on measures taken to implement the court's order on provisional measures 1 week after such order, and then on a regular basis to be fixed by the court. End of quote. Thank you, Madam President.
I thank the registrar. As already mentioned, immediately after the application and the request for indication of provisional measures were filed, the registrar transmitted certified copies thereof to the government of the Russian Federation. He also notified the Secretary General of the United Nations. According to paragraph 74, Article 74, paragraph 1 of the Rules of Court, a request for the indication of provisional measures shall have priority over all other cases. Paragraph 2 of the same provision states that the court shall proceed to a decision on the request as a matter of urgency. As previously noted, this imperative must be balanced with the need to fix the date of oral proceedings in such a way as to afford the parties an opportunity to be represented at the hearings. Consequently, the parties were informed that the date for the opening of the oral proceedings, during which they could present their observations on the request for indication of provisional measures, had been fixed for Monday, 7 March 2022 at 10 a.m. I would now like to welcome the delegation of Ukraine. The agent of Ukraine is present in the Great Hall of Justice. The agent is accompanied by members of Ukraine's delegation, some of whom are physically present in the Great Hall of Justice, while others are participating in the hearings remotely. For purposes of this single round of oral argument, Ukraine has available to it a 3-hour sitting. In this sitting, Ukraine may, if required, avail itself of a short extension beyond 1 p.m. today, in view of the time taken up by these introductory remarks. Before giving the floor to the agent of Ukraine, I wish to draw the attention of the applicant to Practice Direction 11, which states as follows. In the oral proceedings on request for the indication of provisional measures, parties shall limit themselves to what is relevant to the criteria for the indication of provisional measures as stipulated in the statute, rules, and jurisprudence of the court. They should not enter into the merits of the case beyond what is strictly necessary for that purpose. I now give the floor to the agent of Ukraine, Mr. Anton Kornievich. You have the floor, sir.
Madam President, distinguished members of the Court, it is a great honor to appear before you as the agent of Ukraine. It is also a solemn responsibility. We are here today in this building called the Peace Palace, but at home my country faces a war of aggression. I am standing here in a room called the Great Hall of Justice, but at home my countrymen see only the injustice of Russia's bombs and missiles falling on our cities and neighborhoods. As I stand before the court, Ukrainians are under deadly attacks. Millions of people are in imminent danger. The United Nations top human rights officials warns that there are significant civilian casualties. Russia's assault on Ukraine has prompted over 1.5 million people to flee the country. Many more are internally displaced. More than 15,000 people, most of them women and children, have taken shelter in Kyiv's subway tunnels. Babies are born underground there in tunnels, and hospitals are being shelled. All of this is a dire reality the people of Ukraine face now. I serve as President Volodymyr Zelensky envoy to the Autonomous Republic of Crimea, but the war is preventing me from doing my job. We can no longer provide state services to our citizens who reside in occupied territory, including the administrative services, education, medical services, for instance, COVID vaccinations with internationally recognized vaccines. This is, of course, not the first time that Ukraine has experienced first-hand Russia's disrespect for international law. Now the world understands the depth of its disrespect and the hate of its cruelty. The fact that Russia's seats are empty speaks loudly. They are not here in this court of law. They are on a battlefield, waging aggressive war against my country. This is how Russia solves disputes. But Ukraine has another position and respects international law and this court of law. But even still, Russia knows that international law matters. Why else would Russia try to justify its aggression? This war, Russia says, is to stop a genocide. I quote Russia's president from the morning he ordered the invasion of Ukraine. He said, quote, "We had to stop that atrocity, that genocide," end of quote. The purpose of the war, he said, was to protect people from genocide. This is a horrible lie. Putin lies, and Ukrainians, our citizens, die. It is not Ukraine who commits genocide. It is Russia and its political leadership and military personnel who commit crimes against humanity and war crimes on the territory of Ukraine. Over the past 2 weeks, I have heard many people mention World War II. Russia sullies the memory of the Holocaust by claiming to denazify Ukraine. To denazify Ukraine from its democratic government. I have heard others note that Europe has not seen such aggression and conflict since World War II. It is indeed appropriate to recall World War II, but for different reasons. We should recall that in World War II, Ukrainians and Russians fought together and died together to stop evil. We should recall that on the ashes of Europe after the Second World War, the world built the modern pillars of international law. 2 of these pillars stand as the most important. The world witnessed aggression, and it answered with the Charter of the United Nations. The world witnessed the Holocaust, and it answered with a convention to prevent and punish the crime of genocide. The world said never again to the twin evils of Nazism, aggression and genocide. Unfortunately, today, Russia has perverted those words. It does not treat the duty to prevent and punish genocide as a sacred obligation. It treats it as a weapon. With its false claim of genocide, Russia uses one pillar of modern international legal order to destroy the other. by falsely claiming genocide to justify its crime of aggression and acts of aggression, Russia has defiled the Genocide Convention. Madam President, distinguished members of the Court, Ukraine's case is straightforward. Russia accuses Ukraine of committing genocide. Ukraine denies that claim in the strongest possible terms, and we will prove it. Russia claims that in order to stop a non-existent genocide, it can invade a sovereign state, Ukraine. Ukraine rejects this baseless claim. My message to Russia is this: let us settle our dispute like civilized nations. Lay down your arms and put forward your evidence. Ukraine respects this court and follows its orders. Russia must as well. But if Russia will not return to international law on its own, the court has the power to act. With respect, the court has responsibility to act. Russia consented to your jurisdiction under the Genocide Convention. Now it is abusing and violating that convention in order to kill Ukrainians and destroy Ukraine. Russia must be stopped, and the court has a role to play in stopping it. That is why the people of Ukraine, the government of Ukraine, the President of Ukraine, Volodymyr Zelensky, ask you respectfully but urgently to grant our request for provisional measures. Madam President, members of the court, Ukraine's Council here will explain why provisional measures are not only warranted, but vitally necessary. First, Professor Jean-Marc Touvenin will explain that the court has prima facie jurisdiction. Second, Mr. David Zayans will provide the factual background showing that Russia's allegations of genocide are absolutely false. Third, Ms. Marnichik will explain that the rights claimed by Ukraine in this case are at a minimum plausible, which is sufficient for provisional measures to be indicated. Fourth, Mr. Jonathan Gimblent will explain that the Ukrainian people are vulnerable in an urgent need of the court's protection. Fifth, Professor Harold Honju-Ko will explain the measures Ukraine requests and why those measures must be ordered. Finally, Ms. Oksana Zolotaryova, co-agent of Ukraine, will conclude and present Ukraine's closing statement and final submissions. On behalf of Ukraine, I thank the court for the urgency you showed in convening this hearing. I thank you, Madam President, for your urgent communication to the Russian Federation under Article 74, Paragraph 4 of the court rules. I thank the court in advance for your careful attention this morning, and I thank the court for being mindful of the extreme urgency which exists now as you deliberate. If ever there was a moment in which to exercise your power to order provisional measures, this is that moment. I now ask you to give the floor to Professor Jean-Marc Touvenin.
Thank you, Mr. Kornievich. I now invite Professor Jean-Marc Touvenin to take the floor. You have the floor, Professor.
Thank you, Madam President. Madam President, distinguished members of the court, counsel who are appearing before you today would like you to know how honoured they are to do so. This is not just polite lip service, it's obvious given how much respect and confidence that this World Court, the principal judicial organ of the UN, the World Court, inspires and gives a solid weight to the conviction shared by those who come to this bar, that international law is not an empty promise. Today, the feeling which strikes me, which strikes us all, not only on this side of the bar, but everywhere in Ukraine and beyond, everywhere in the world, is that of extreme urgency to hear your court play its full part in the action undertaken by the United Nations and the world. Extreme urgency to bring to an end without delay this war purporting to prevent an alleged genocide and the punishment launched against Ukraine, its leaders, its people, its identity, against its very existence by President Vladimir Putin on 24 February 2022. This, under the guise of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. Now, some people will say that 24 February 2022 is a black day in the history of the Convention for 48. In truth, at that date, Russia reduced it to confetti. Your court, Madam President, distinguished members of the court can, and I believe must, make it whole again. And I'm sure that you will do so, but that will take time, and time, well, that's one thing we don't have. And that's why Ukraine requests your court to act swiftly, indicating the provisional measures requested. You can do it. And Ukraine believes that you must do it. All the conditions are met for this, and I will demonstrate, as you've already heard, that your jurisdiction, which need only be prima facie, is established. Following me, Mr. Zions will demonstrate the total emptiness of those allegations of genocide proffered by Russia. Then Ms. Cheek will show that those rights whose protection is sought by Ukraine, the right not to be victim of a delusional interpretation and application of the Genocide Convention, the right not to see its territory devastated, its population terrorized in the name of the Genocide Convention, that these rights claimed by Ukraine are, according to the accepted formula, at least plausible. Mr. Gimblett will tell you we have unfortunately moved well beyond the risk of irreparable prejudice and that there is extreme urgency. I mean, really, it is the wholly relevant term here to avoid more death and destruction. Finally, Professor Coe will explain why the provisional measures requested by Ukraine are appropriate in the extraordinary current circumstances of the case, and the co-agent of Ukraine will wind up this morning's session. So let me come now to prima facie jurisdiction. In this respect, Madam President, Ukraine would like to point out that Russia decided not to appear before you without giving the least explanation, justification for that. Let me point out that in other cases, Russia argued tooth and nail that you lacked jurisdiction. As prolix as its able counsel were then, here Russia remains silent. You will see there Russia's acknowledgement that they cannot challenge the prima facie jurisdiction of your court. And Ukraine shares this opinion. Madam President, distinguished members of the court, as you have recalled a number of times, and recently indeed again, I quote, the court may indicate provisional measures if the provisions relied on by the applicant appear prima facie to afford a basis on which its jurisdiction could be founded, but need not satisfy itself in a definitive manner, that it has jurisdiction as regards the merits of the case. Now, your powers and competencies are founded on Article 36, Paragraph 1 of your statute and Article 9 of the Genocide Convention. This latter text is well known to the court, but I'm going to quote it nonetheless. Disputes between the contracting parties relating to the interpretation, application, or fulfillment of the present convention, including those relative to the responsibility of a state for genocide or for any other acts enumerated in Article 3 shall be submitted to the International Court of Justice at the request of any of the parties to the dispute." End of quote. Now, ratione personae jurisdiction requires no debate. Russia and Ukraine are both parties to the Genocide Convention, and neither of them have made a reservation which is currently in force. Regarding ratione materiae jurisdiction, what you have to check at the stage of provisional measures is the prima facie existence of a dispute relative to the interpretation, application or fulfillment of the Convention. Now, the key points of your case law with respect to the concept of dispute, which are recalled in the Marshall Island case, can be summarized as follows. A dispute is a disagreement on a point of law or fact, a conflict of legal views or interests between parties. For a dispute to exist, it must be shown that the claim of one party is positively opposed by the other. The two sides hold clearly opposite views concerning the question of the performance of non-performance of certain international obligations. Now, this is a substantive question. It's not formalistic or procedural, and it calls for an examination of the facts. Now, to this end, the court will, inter alia, take account of all declarations or documents exchanged in multilateral fora, and in so doing, the court accords particular attention to the author of the statement or document, their intended or actual addressee, and their content. The behaviour of the parties may also be taken into account, specifically in the absence of diplomatic exchanges. The disagreement need not necessarily be stated expressis verbis. As in other matters, the position or the attitude of a party can be established by inference, whatever the professed view of that party. In particular, the court has ruled that the existence of a dispute could be inferred from the failure of a state to respond to a claim in circumstances where a response is called for. Now, Madam President, distinguished members of the court, it is clear that Ukraine has many grievances to assert against Russia. But what is before you is a very delineated dispute. It's a dispute relative to the interpretation, application or fulfillment of the Genocide Convention. And it takes a twofold form. The first expression of this dispute relates to the fact that, according to Russia, Ukraine has committed genocide in the oblasts of Donetsk and Luhansk. This accusation lies at the heart of the decision of the Russian Federation of 2022. It is the only legal justification advanced by Russia to justify its attack on Ukraine as a whole. Now, this serious accusation doesn't date from 24 February 2022. In fact, Russia has repeated it consistently, even ever more vehemently for the last 8 years, as I shall now show. But before doing that, Madam President, may I point out that all the facts that I'm going to mention are all duly established in documents which can be found in the judges' folders, so you can consult them when that suits you. I would also like to point out that I will quote certain documents, some of which are in Russian. I'm going to quote them in a French version, which isn't official, which I think is reliable, in order to simplify the work of the interpreters. Now, for your comfort, a translation in English of the Russian language documents is also available in your case files. So let me come to the facts, in particular to the allegations of genocide. As of 2014, the newspaper Nezavisimaya Gazeta, edited in Moscow, published an article, the French version of which was edited by the magazine Courrier International, entitled, I quote, Ukraine-Russia accusation of genocide towards a Kosovo-type scenario, question mark. Its author underlines that now the word genocide is heard more and more clearly, end of quotation, but pointed out that it will be extremely difficult for Russia to get Western countries' recognition of genocide in eastern Ukraine, end of quotation. Now, this article in the press came at the same time as the Russian Federation's investigation committee's opening of an inquiry into, I quote, the genocide of the Russian-speaking population living in the Oblast of Luhansk and Donetsk. The Russian Federation's investigation committee is an official Russian agency mandated with criminal prosecutions at federal level, which reports directly to the President of the Russian Federation. Its communique indicates that, and I quote, the investigation found that during the period from 12 April 2014 to the present, in violation of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, as well as other international legal acts prohibiting genocide, unidentified persons from among the top political and military leadership of Ukraine, the armed forces of Ukraine, the National Guard of Ukraine, and the right sector, I don't know how to translate that, gave orders to completely destroy specifically Russian-speaking populations living on the territory of the Donetsk and Luhansk republics. End of quote. In January 2015, new penal prosecutions were set in train by Russia following the alleged bombing of the east of Ukraine by the Ukrainian army. The investigation committee of Russia asserted, I quote them, such acts carried out by the Ukrainian military constitute especially grave crimes, not only under Russian law, but also under the norms of international law, in particular, the Convention on the Prevention and Punishment of the Crime of Genocide and others. End of quote. In February 2015, the world press, for example, Le Soir in Belgium, pointed out that the president of the Russian Federation, Vladimir Putin, had asserted that the refusal of the Ukrainian authorities to supply gas to the provinces in the east, I quote, already looked like genocide, end of quotation. On 10 September of the self-same year, an official communique of the Investigation Committee of Russia announced that it was going to initiate new prosecutions against an indefinite number of Ukrainian officials, including the Minister of Defense and other named military officials, on the grounds that they had allegedly violated, inter alia, the Convention on the Prevention and Punishment of Genocide. And during an interview with Russian media, Vladimir Markin, official representative of the Russian Prosecution Service, said, I quote him, I would like to remind you that current Russian legislation, as well as the norms of international law, allow Russian investigative bodies to prosecute these people. And we're talking about extraterritorial jurisdiction, where the universal principle applies. The same official spelled out that Russia intended to exercise this extraterritorial jurisdiction, quoting, in cases provided by an international treaty of the Russian Federation if foreign nationals have not been prosecuted in a foreign state, end of quotation. In September 2017, the Russian Investigation Committee announced criminal proceedings against 20 other senior officials in Ukraine's defense ministry, including the Ministry of Defense himself. According to the representative of the investigation committee, the same Vladimir Markin, I quote him, These persons, in violation of the Convention on the Prevention and Punishment of the Crime of Genocide and others, exercising the general control over military operations, gave deliberately criminal orders to the soldiers of law enforcement agencies of Ukraine to conduct targeted artillery shelling of civilian infrastructure. In November 2021, the President of the Russian Federation adopted a decree, a ukaz, with respect to eastern Ukraine. The ambassador of the Russian Federation in the contact group for the settlement of the situation in eastern Ukraine, Boris Kryzlov, stated then that this decree was a response to the actions of Kyiv, I quote him, which actually fall under the United Nations Convention on the Prevention of Genocide. End of quote. Now, Madam President, distinguished members of the Court, this is not some trivial event. Indeed, the accusation of a violation of the UN Convention on the Prevention and Punishment of Genocide, repeated year after year by the Russian prosecution service, had just been rehearsed and ratified by one of the senior officials of the Russian Federation regarding international relations between Russia and Ukraine. The accusation from then on clearly took on an international character and was largely relayed by official media of Russia. Let's not get it wrong, agents, the TASS agency, of course, but also by RIA Novosti, other Russian media, clearly understanding the message, then put up headlines. What Kyiv is doing in the Donbass falls under the Genocide Convention. On 9 December 2021, the President of the Russian Federation maintained to a journalist of Russia Today that what's happening, and I'm quoting him, what's happening right now in the Donbass, you and I can see it. We know it. That is a genocide that you have mentioned. The assertion, this time, from the most senior official of the Russian state, its president, was obviously taken up by all official Russian media, inter alia TASS agency, but also by the world press. In France, for example, in Le Point. On 10 December 2021, the Vice President of the Duma Committee for International Affairs, Alexei Chepa, told Russia Today, that's official Russian media, that he unreservedly supported the words of the President of the Russian Federation. I agreed wholeheartedly, he said. His people are purely and simply being annihilated. The article of Russia Today recalls, furthermore, the position of Ambassador Boris Kryzlov, who I mentioned a little earlier, who had posited that Russia's grievance with Ukraine fell under the Convention of the United Nations on the Prevention of Genocide. On 16 February 2022, during the press conference at the end of a meeting between the President of the Russian Federation and the German Chancellor Olaf Scholz, which concerned this meeting concerned specifically the threat of military action of Russia against Ukraine, the Russian president justified in advance such an action by accusing Ukraine of genocide. On 18 February 2021, the president, error in my text, that should be, of course, 18 February 2022, the president of the Russian parliament, Vyacheslav Volodin, accused Ukraine once again of committing acts in the east of the country, acts which international agreements prohibit. And he spells it out clearer. If it's not genocide, then what is it? End of quotation. I quote him once again, warning that, I quote, the authors doubtless will be punished. Now, 3 days later, in his speech of 21 February 2022, justifying his decision to recognize the sovereignty of the so-called republics of Donetsk and Luhansk, the president of the Russian Federation accused, and I'm quoting him now, the so-called civilized world, which our Western colleagues proclaimed themselves the only representatives of, prefers not to see this, as if the horror and genocide faced by nearly 4 million people did not exist. But they do exist, end of quotation. In his speech of 24 February 2022, rehearsing once again the allegations reiterated by Russia since 2014 under the guise of the Genocide Convention, the Russian head of state accuses once again Ukraine of genocide, stating that the military action launched on that fateful day, I quote him here, the purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime. On 25 February 2022, Russian Federation's ambassador to the EU, Vladimir Chisov, confirmed in an interview with Euractiv that the allegation of genocide against Ukraine was done so with reference to the Genocide Convention. On 28 February 2022, the Russian Federation's foreign minister came back to the fray, accusing this time the EU of having taken the side of, I quote him, the Kiev regime, which has embarked on a policy of genocide of its own population. Now, Madam President, distinguished members of the court, it serves nothing to accumulate any more evidence showing that what Russia reproaches Ukraine of, and which formed the basis of its decision to punish Ukraine militarily, is to have allegedly committed acts contravening the UN Convention for the Prevention and Punishment of Genocide. Is this the cause of the dispute? Well, how could one possibly doubt it? Ukraine deeply disagrees with this allegation, which they always have found as totally grotesque. Ukraine let Russia know that time and time again, starting September 2014. In a report of the BBC, the advisor of the Minister of the Interior of Ukraine pointed out the Ukrainian prosecutors' offices had initiated penal prosecution against agents of the Russian Investigation Committee accused by Ukraine of aiding a terrorist organization in the Donbass and obstructing the application of the law and the work of state agents precisely because they had accused Ukraine of genocide in the Donbass. The advisor added that according to Ukraine, those accusations of genocide made by the suspects had as their sole objective the justification of the occupation of the Donbass. Now, I could stop there. It's so evident that when one state accuses the other of breaching the Genocide Convention and the other initiates judicial proceedings against the agents of the former on the grounds that they've been making false allegations, that a dispute relative to the interpretation, application or fulfillment of the Convention on Genocide is incontrovertibly established. Furthermore, the dismissal of Russian accusations as totally unfounded wasn't limited to Ukraine. You will remember, because it happened less than a month ago, on 16 February 2022, the US State Department had denounced the accusation of genocide advanced by Russia as aimed at fabricating a pretext to launch a military invasion of the Ukraine. As to the German Chancellor, he denounced the Russian accusation of genocide as laughable, triggering the ire of the Russian Federation's foreign minister. As to Ukraine, well, it once again showed its disagreement with Russia via its foreign minister. On 23 February 2022, before the UN General Assembly, when the ambassador of Russia to the United Nations Organization, Vasily Nebenzia, justified the lawfulness of the Russian recognition of the independence of Oblast of Donetsk and Luhansk, saying, you can see it on the left here of the screen, given the flagrant genocide and the trampling of the most important of human rights, the right to life, our country cannot remain indifferent to the fate of the 4 million people in the Donbass. Flagrant genocide? Mr. Kuleba, Ukraine's foreign minister, responded, I quote him, Russia's accusations of Ukraine are absurd. Ukraine has never threatened or attacked anyone. Ukraine has never planned and does not plan any such action. Russia's actions and statements are outrageous, horrific, and go far beyond threatening Ukraine. In fact, in his address this week, Russian President Vladimir Putin overtly denied Ukraine's right to exist. End of quotation. On 26 February 2022, Ukraine's foreign minister forcefully reiterated the dismissal by Ukraine of accusations of violation of the Genocide Convention as being baseless. Let me quote the communiqué, which the judges can find in their folders. Ukraine strongly denies Russia's allegations of genocide and denies any attempt to use such manipulative allegations as an excuse for unlawful aggression. The crime of genocide is defined in the Genocide Convention, and under that convention, Russia's claims are baseless and absurd. Russia's claims of genocide as justification for its lawless conduct are an insult to the Genocide Convention and to the work of the international community in preventing and punishing the world's most serious crime. End of quote. Madam President, distinguished members of the Court, these facts speak for themselves. They confirm the existence, at least prima facie, of a dispute between the parties, which can be summed up as follows. Russia accuses Ukraine of engaging in acts and in a policy of genocide within the meaning of Article 2 of the Convention. Ukraine retorts that these allegations are absurd, even odious, because they are obviously legal window dressing for an armed aggression. This dispute falls within the provisions of Article 9 of the Convention. Your prima facie jurisdiction to entertain it is thus established.
But this does not exhaust the subject, because, as I said, the dispute includes a second, even more serious aspect, which concerns the actions that a state can or must take with regard to another state that is also party to the convention that it accuses of genocide. According to Russia, the denunciation of the alleged genocide that it blames on the Kiev regime, calling it Kiev, the so-called Nazi junta led by President Zelensky, would authorize it and its continuation and to punish alleged perpetrators by means of a war against that state aimed at protecting the victims of the alleged genocide, tracking down those perpetrators, alleged perpetrators, and bringing them to trial. It is true, Madam President, distinguished members of the Court, that Article 1 of the Convention provides that states have the obligation to prevent and punish genocide. That is to say, in the words of your Court, and I quote, all means reasonable available to them should be used so as to prevent genocide so far as possible. End of quote. It is also true, as the Court held, that according to Article 1 of the Convention, and I quote, the obligation of each state to prevent and to punish the crime of genocide is not territorially limited by the Convention. These are the words of the Court. End of quotation. However, nothing in the Convention authorizes a state to enter by force the territory of another state to prevent or punish or prevent or punish genocide. And indeed, you held in 1986 in Nicaragua versus the United States that, and I quote, where human rights are protected by international conventions, that protection takes the form of such arrangements for monitoring or ensuring respect for human rights as are provided for in the conventions themselves. End of quote. And you also added that while each state makes its own assessment of the human rights situation in a third country, and I quote the court once again, the use of force could not be the appropriate method to monitor or ensure respect of these rights. End of quote. However, it is exactly the opposite that Russia claims through, in particular, but not only, its president. In his 21st February 2021 speech, referring to the events in Odessa in 2014, when the first allegations of genocide were made, the Russian president said, and I quote, "One shudders at the memories of the terrible tragedy in Odessa where peaceful protesters were brutally murdered, burnt alive in the House of Trade Unions. The criminals who committed that atrocity have never been punished, and no one is looking for them. But we know their names." That's what the president said, the Russian president. And this was in February 2021, that we know their names and we will do everything to punish them, find them and bring them to justice. End of quote. The same leader also argued in his 24th of February 2022 speech announcing the so-called special military operation that, and I quote, its goal is to protect the people who have suffered abuse and genocide at the hands of the Kiev regime for 8 years. The purpose of this operation is to protect people who for 8 years now have been facing humiliation and genocide perpetrated by the Kiev regime. To this end, we will seek to demilitarize and denazify Ukraine as well as bring to trial those who perpetrated numerous bloody crimes against civilians, including against citizens of the Russian Federation. End of quote. In other words, according to Russia, there is no other possible rationality for the justification put forward by its president at the very moment he ordered the invasion of Ukraine. The Convention on the Prevention and Punishment of Genocide gives him the right, perhaps even the duty or the responsibility to prevent by denazifying and to punish by hunting down and by bringing to trial the alleged genocide perpetrated in Ukraine by means of a special military operation. Madam President, distinguished members of the Court, Ukraine strongly disagrees with Russia's interpretation, application, or fulfillment of the Convention by Russia. As for Russia, it could not have been unaware that its views were positively opposed by Ukraine. What Russia could do under Article 8 was to call upon the organs of the United Nations. What Russia could have done under Article 9 was to file an application against Ukraine before this court. Ukraine argues that Russia, on the other hand, has strictly no right under the Convention to take the military action that began on 24th of February 2022. Because, unlike Russia, Ukraine considers, as your court did, in the Bosnia-Herzegovina genocide case that on the basis of the convention, and I quote, "It is clear that every state may only act within the limits permitted by international law." End of quote. Ukraine is resisting. Ukrainian men and women are suffering. Ukrainian men and women are dying. They could not have demonstrated their dispute with Russia more forcefully. Madam President, members of the court, the dispute over the interpretation, application, or the fulfillment of the 1948 Genocide Convention between Ukraine and Russia is not just about angry words. It is also forged in iron, in flames, in blood, in screams and tears. Your prima facie jurisdiction to hear this case is beyond doubt. Ukraine is asking you to exercise it by indicating the provisional measures that it has requested you to order. It is asking you to give substance to the conviction shared by a lot of those who stand here that international law is not just an empty promise. That concludes my remarks, Madam President. I would like to thank you for your very patient attention, as always, and I would respectfully ask you to give the floor to Mr. David Zients. Thank you.
And I now give the floor to Mr. David Zients. You have the floor, sir.
Madam President, members of the court, I am honored to appear before you on behalf of Ukraine. Ukraine comes to this court because of a grotesque lie and to seek protection from the devastating consequences of that lie. The lie is the Russian Federation's claim of genocide in Ukraine. The consequences are unprovoked aggression, cities under siege, civilians under fire, humanitarian catastrophe, and refugees fleeing for their lives. You have just heard why Russia's claim of genocide, opposed by Ukraine, creates a dispute under the Genocide Convention over which the court has jurisdiction, certainly on a prima facie basis. I will now step back to explain the factual context of Russia's allegation so that the court can understand its falsity and the lack of any hint of plausibility. Russia would have the world believe that Ukraine launched a genocidal war on its own people in the Donbass. Even a basic understanding of the facts shows this to be false. In addressing the facts, 2 points should be stressed. First, the full history of Russia's mistreatment of Ukraine is not before the court. This case is about false claims of genocide in the war Russia launched to purportedly prevent and punish alleged acts of genocide. I will focus on only the background that will be most helpful to the court in appreciating the falsity of Russia's allegations. Second, in political forums, Russia presents a narrative based on forgeries, fakes, and distortions. In this legal forum, I will not present one country's narrative against another's. I will present the fact as documented by UN human rights bodies and officials and similarly credible, neutral observers. Madam President, in February 2014, the Ukrainian people rose up in a revolution of dignity. Russia responded with aggression, invading and occupying the Autonomous Republic of Crimea and the city of Sevastopol. Then, as now, Russia's aggression was based on lies. Russia first denied that it had used its military. Then President Putin admitted it. Then he claimed without basis that, quote, the Russian-speaking population was threatened, end quote. The international community rejected Russia's actions, and the UN General Assembly passed Resolution 68262, overwhelmingly reaffirming the territorial integrity of Ukraine, including Crimea. With Crimea occupied, Russia tried to apply the same tactics to the Donbas region of eastern Ukraine, spanning the Donetsk and Luhansk oblasts. But Russia did not find support. So instead, it looked to illegal armed groups to advance its agenda. These groups called themselves the Donetsk People's Republic, or DPR, and the Luhansk People's Republic, or LPR. This is how the UN Human Rights Monitoring Mission in Ukraine described the DPR and LPR in May of 2014, the earliest days of the conflict. The mission is concerned with the undermining of human rights protection and guarantees of fundamental freedoms for the population of the town where buildings are occupied by armed persons, as well as the broader population of eastern Ukraine. Specifically, the UN mission is concerned about the rise in the number of reported cases of intimidation, harassment, and killings, as well as the wave of abductions and unlawful detentions of journalists, activists, local politicians, representatives of international organizations, and members of the military. 1 month later, the UN Human Rights Mission reported as follows: violence and lawlessness have spread in the regions of Donetsk and Luhansk. Having gained access to deposits of weapons, the armed groups increasingly started spreading violence. Increasingly, attacks target ordinary people who take no part in the fighting. And here is the UN Human Rights Mission 1 month after that, in July 2014. Grave human rights abuses have been committed by those armed groups. And it must be remembered that these groups have taken control of Ukrainian territory and inflicted on the populations a reign of intimidation and terror to maintain their position. Ukraine was therefore faced with illegal armed groups controlling territory, murdering civilians, and waging a campaign of terror. Any responsible government in this situation would work to restore law, order, and respect for human rights. And that is what Ukraine did. The early history of Ukraine's operation is documented, again, by the UN monitoring mission. It reports on Ukraine's efforts to limit the operation, calling an early stop to it in observance of Easter. But Ukraine was compelled to resume the operation, quote, following the discovery of the bodies with alleged signs of torture of Volodymyr Rybak, Horlivka city councillor, and Yuri Popravko, a student and Maidan activist from Kiev, in a river near Slovyansk on 19 April. This refers to a well-known incident discussed at the UN Security Council in which Mr. Rybak was kidnapped, tortured, and assassinated by the DPR for the crime of raising the Ukrainian flag. Ukraine resolved to secure its territory and protect its people. On their own, and without meaningful popular support, it is difficult to imagine the DPR and LPR maintaining any territory for long. But these illegal armed groups found eager sponsors in Russia. In December 2014, the UN Human Rights Monitoring Mission reported that, quote, the total breakdown in law and order and the violence of fighting in the eastern regions, end quote, was, quote, fueled by the cross-border inflow of heavy and sophisticated weaponry as well as foreign fighters, including from the Russian Federation, end quote. The ICC Office of the Prosecutor has likewise tied the increased intensity of fighting to influxes of troops, vehicles, and weaponry from the Russian Federation. Over time, Russia's influence and control and overt role in the conflict grew, and in 2018, Ukrainian legislation declared the Donbass occupied territory. Fueled by Russia, the carnage in eastern Ukraine grew. I will highlight only one example: the shelling of a residential district in Mariupol on 24 January 2015. 30 civilians died in the attack. According to the UN Secretary General, the attackers fired indiscriminately into civilian areas. The Undersecretary General for Political Affairs elaborated that they knowingly targeted a civilian population. I should add that Mariupol is a Russian-speaking city. Russia's claim to be the protectors of Russian-speaking people in Ukraine did not protect Mariupol from a barrage of Russian rockets in 2015, just as it is not protecting Mariupol today from a Russian siege army that is bombarding the city and cutting off its power, water, and heat. Madam President, members of the court, these are the circumstances in which Russia claims that Ukraine has been committing genocide against its own people. It would be an understatement to say that Russia has provided no evidence for acts of genocide in the course of this conflict. The closest President Putin has come to even explaining his allegation of genocide is to assert, as he did on 21 February of this year, that, quote, not a single day goes by without Donbass communities coming under shelling attacks, end quote. This is another flagrant lie for which Russia has offered no support. Shortly, Ms. Cheek will apply the definition of genocide under Article 2 of the Convention and show that no such acts have been committed. For now, I will make 3 factual points. First, Ukrainian civilians on both sides of the contact line have suffered from a conflict which Russia has funded and fueled and increasingly waged itself. Tragically, Ukraine's adversaries have had no regard to the lives of civilians on their side of the line. This is not Ukraine's position alone. It is a fact documented by the UN Human Rights Monitoring Mission, quote, the armed groups are locating their military assets in and conducting attacks from densely populated areas, thereby putting the whole civilian population at risk. The civilians on both sides of the line are Ukrainian, and Ukraine regards every civilian death in this conflict as a tragedy. But to claim that Ukraine targets civilians is to distort facts. As I noted a moment ago, in the course of this conflict, top UN officials condemned the DPR for knowingly targeting a residential area. You will not find anything that comes close to that about Ukraine. Second, if there were attacks on civilians rising to the level of genocide, allegedly warranting an armed invasion, one would think there must have been a massive recent escalation in civilian casualties, at the least. Yet that is transparently not the case. UN human rights monitors have tracked the year-over-year civilian casualties in the conflict. The UN statistics on your screen show a dramatic decrease. These figures, moreover, cover both sides and do not reflect any conclusion of civilians being targeted. To be clear, Ukraine regards as tragic each of the 15 deaths recorded as of the date of the most recent report in 2021. But Russia's claim that Ukraine is targeting civilians is a clear fabrication. Indeed, as recently as 22 December 2021, the OSCE announced a renewed ceasefire agreement. As further explained in a recent report by The Guardian, quote, "The OSCE logs regular firing between Moscow armed separatists and Ukrainian soldiers. In recent months, this low-level conflict has been relatively calm, as Russia has moved 150,000 troops to Ukraine's borders, and Ukrainian soldiers have been under instructions not to return fire," end quote. Third, if one point should be clear from my presentation, it is that UN human rights monitors have been meticulously tracking the conflict in Donetsk and Luhansk from its inception to the present. In 8 years of reporting, there is not a single hint of any act of genocide. The OSCE has logged every ceasefire violation, and you will not find in its reports any evidence of genocide. Ukraine has recognized the jurisdiction of the International Criminal Court, whose jurisdiction includes the crime of genocide. The Office of the Prosecutor has been examining the situation for 7 years and found evidence of crimes, but has never said a word about genocide. In short, Russia's claim is that a genocide has occurred under the noses of diligent UN fact-finders, OSCE monitors, and ICC prosecutors. It defies credulity. I turn finally to the present. For months, the world watched Russia mass its forces along Ukraine's borders. Yet as recently as 31 January 2022, at a meeting of the UN Security Council, the permanent representative of Russia reacted angrily to suggestions that Russia planned to invade. He mockingly called on the United States to, quote, "show us at least some evidence, apart from bogus narratives fabricated in their own heads, that Russia intends to attack Ukraine." That was a lie. Little more than 3 weeks later, Russia did attack Ukraine. The same permanent representative would justify his country's invasion based on claims of genocide. Another lie. To the end, Russia appeared desperate to manufacture a casus belli. But plans to stage false flag attacks were exposed. Shelling was intensified along the contact line to provoke retaliation, but Ukraine would not oblige. On 17 February, a horrific act of violence did occur in Luhansk Oblast when a kindergarten was attacked. The OSCE called this indiscriminate shelling. Yet the kindergarten was in government-controlled territory. As Human Rights Watch reported from the ground, the attack appeared to have been committed, quote, by Russia-backed armed groups, end quote. Russia thus found itself eager to invade Ukraine, but lacking any conceivable justification. So Russia settled on its lie. President Putin would dramatically trumpet his accusation of genocide. Russia would recognize the DPR and LPR as independent states on the basis of the genocide they allegedly faced. And Russia would invade Ukraine for the express purpose of protecting the people of Donbass from this fabricated genocide and to punish the supposed génocidaire. With the groundwork laid, the claim of genocide invoked, Russia proceeded to unleash the military aggression that is now horrifying the world. Madam President, members of the court, as we speak, Russian speakers in Ukraine are indeed under attack. Ukrainians are under attack regardless of what language they speak. They are under attack from Russia. Médecins Sans Frontières reported 2 days ago that, quote, the humanitarian situation in Mariupol is catastrophic, end quote. The predominantly Russian-speaking city of Kharkiv is under barbaric attack, with cluster munitions being launched indiscriminately at residential areas. According to a UN report, in the first 6 days of Russia's war, there were nearly as many civilian casualties as in the last 5 years of the Donbass conflict. And that is just confirmed casualties, with the UN recognizing that the real number is much higher and climbing every day. Yet Russia has the gall to massacre Ukrainians and call it protection. Russia has the gall to attempt to overthrow a democratically elected government and call it punishment of Nazis. Russia has the gall to accuse Ukraine of a fake genocide and to rain very real destruction and terror on the 44 million inhabitants of a sovereign state. Madam President, the facts are undeniable. Russia's allegations of genocide are false and outrageous. I respectfully ask that you call on Ms. Marnichik, who will explain the plausibility of the rights Ukraine asserts under the Genocide Convention.
I thank Mr. Zients, and I now invite Ms. Marnichik to take the floor. You have the floor, Ms. Cheek.
Madam President, distinguished members of the court, it is an honor to appear before you again on behalf of Ukraine. I will discuss the rights that Ukraine seeks to preserve through its request for provisional measures. As stated in this court's order on provisional measures in the Gambia versus Myanmar, and here I substitute Ukraine for the Gambia, quote, at this stage of the proceedings, the court is not called upon to determine definitively whether the rights which Ukraine wishes to see protected exist. It need only decide whether the rights claimed by Ukraine on the merits and for which it is seeking protection are plausible. In this case, the rights asserted by Ukraine are plausible, as they are, to again quote the court in Belgium v. Senegal, grounded in a possible interpretation of the Convention. Indeed, the rights that Ukraine asserts are grounded in a good faith interpretation of the Convention, while Russia's use of the Genocide Convention to try to mask its unlawful invasion of Ukraine can only be described as proceeding in bad faith in violation of the Convention. This morning, I will first describe the rights and obligations that exist under the Genocide Convention. Second, I will explain that there is no plausible evidence of genocide in the Donbass region of Ukraine. Third, and finally, I will elaborate on Ukraine's right to demand good faith performance and to not be subjected to abuse or misuse of the Genocide Convention. So let me first describe generally the rights and obligations under the Genocide Convention. Article 1 of the Genocide Convention confirms that genocide is a crime under international law, which the contracting parties, quote, undertake to prevent and punish. This court has interpreted Article 1, observing in the Bosnia genocide case that while the Genocide Convention, quote, does not expressis verbis require states to refrain from themselves committing genocide, that is precisely what the duty to prevent genocide necessarily implies. The court went on to further explain the obligation to prevent genocide as follows, quote, a state's obligation to prevent and the corresponding duty to act arise at the instant that the state learns of, or should normally have learned of, the existence of a serious risk that genocide will be committed. From that moment onwards, if the state has available to it means likely to have a deterrent effect, or those suspected of preparing genocide, or reasonably suspected of harboring specific intent, dolus specialis, it is under a duty to make such use of these means as the circumstances permit. Thus, consistent with the object and purpose of the Genocide Convention to liberate mankind from the odious scourge of genocide, Article 1 includes both an obligation not to commit genocide, as well as a duty to act to prevent and punish genocide. With regard to the duty to act, where there is a serious risk of genocide, states should take preventative measures likely to have a deterrent effect. Further, under Article 4 of the Convention, quote, persons committing genocide or any of the other acts enumerated in Article 3 shall be punished, whether they are constitutionally responsible leaders, public officials, or private individuals. Russia has acted inconsistently with these obligations and duties. It has fabricated a claim of genocide in the Donbas region of eastern Ukraine. It has then justified its military invasion of the entire country as the prevention of that fabricated genocide and as punishment of the alleged perpetrators of genocide through so-called denazification. It has not taken preventive measures likely to have a deterrent effect. As this court explained in its 1951 advisory opinion on the reservations to the Convention on Genocide, the Convention was manifestly adopted for a purely humanitarian and civilizing purpose. It is indeed difficult to imagine a convention that might have this dual character to a greater degree, since its object, on the one hand, is to safeguard the very existence of certain human groups, and on the other, to confirm and endorse the most elementary principles of morality. In such a convention, the contracting states do not have any interests of their own. They merely have one and all a common interest, namely the accomplishment of those high purposes which are the raison d'etre of the Convention. Consequently, in a convention of this type, one cannot speak to individual advantages or disadvantages to states or to the maintenance of a perfect contractual balance between rights and duties. The high ideals which inspired the Convention provide, by virtue of the common will of the parties, the foundation and measure of all of its provisions. The Russian Federation has flouted these ideals. It does not act with high purposes. It does not act with common interest with the other parties to the convention. Instead, Russia has invoked the rights and duties recognized by the convention in bad faith. It has abused and misused them, unilaterally invoking genocide as a legal shield for its unlawful aggression against Ukraine. As Ukraine's cities are destroyed and its people killed in the name of preventing and punishing genocide, the Convention's humanitarian and civilizing purpose is being turned inside out. The object and purpose of the Convention is being defeated. Let me now explain, for the avoidance of doubt, that there is no plausible genocide in the Donbas region of Ukraine. The duty to prevent and punish genocide only arises when there is an actual genocide or a serious risk of it. Contrary to Russia's claims, there is no genocide or serious risk of it in the Donbas region. Genocide is defined in Article 2 of the treaty as, quote, acts committed with intent to destroy a national, ethnical, racial, or religious group, including killings, causing serious bodily injury or mental harm, and deliberately inflicting conditions of life calculated to bring about physical destruction. There is simply no plausible evidence that Ukraine perpetrated such acts in the Donbas region of Ukraine or anywhere else. There is certainly no plausible evidence of the required dolus specialis, or specific intent, which this court has explained sets a high bar for proving the extraordinarily serious allegation of genocide. As Mr. Zients explained, there has been fighting in eastern Ukraine for the last 8 years. This has tragically led to civilian deaths. But civilian deaths in an armed conflict are not, per se, genocide. First of all, the requisite actus reus must be satisfied. In Croatian genocide, your court explained, quote, if one takes the view that the attacks were exclusively directed at military targets and that the civilian casualties were not caused deliberately, one cannot consider those attacks, inasmuch as they caused civilian deaths, as falling within the scope of Article 2A of the Genocide Convention. That is the situation in Donetsk and Luhansk, at least as regard to the actions of Ukraine. There is no plausible evidence that the civilian casualties in the Donbas region were caused deliberately by Ukraine. There is thus no plausible evidence that Ukraine committed killings within the meaning of Article 2. Nor is there any plausible evidence that Ukraine committed any of the various other Article 2 acts against civilians in the Donbas region. Without satisfying the actus reus under Article 2, there is no genocide under the Convention. But it is worth mentioning that there is also no evidence of the required mens rea of genocide. No evidence that Ukraine acted with the specific intent of destroying a particular national, ethnic, racial, or religious group. Russia has seemed to suggest that its invasion is to liberate the Russian speakers in the Donbas region. But there are many cities in Ukraine, including in the Donbas region, that are predominantly Russian-speaking, yet do not welcome Russia's actions. To give just one example, Mariupol, a major port city in southeastern Ukraine, it is predominantly Russian-speaking. Yet there are no signs of Ukrainian human rights violations in Mariupol. Today, Mariupol is suffering a humanitarian crisis inflicted upon it by the Russian military, which will not allow safe passage for civilians as the Ukrainian government seeks to protect its citizens there. Quite simply, Russia's sweeping claim of a genocide, which almost 4 million people are facing, has no plausible basis in fact.
Ms. Cheek, may I kindly interrupt you before you begin the next section of your presentation, as it appears that this would be a good time for a coffee break of 10 minutes.
Yes, thank you.
Sitting is adjourned. Please be seated. The sitting is resumed, and I now give the floor back to Ms. Cheek to continue with her presentation. You have the floor.
Madam President, members of the Court, I will now elaborate on Ukraine's right to demand good faith performance of the Genocide Convention and to not be subject to an abuse or misuse of the Genocide Convention. Without a plausible predicate act of genocide or a serious risk of it, Russia has no duty to prevent or punish under the Genocide Convention. Indeed, in order to act consistently with the object and purpose of the Convention, Russia has a duty not to act in the name of preventing and punishing genocide, since no genocide exists. Simply alleging genocide cannot give a state a right under the Convention to carry out a unilateral military operation against another state in order to prevent and punish the alleged genocide. As held by your court in military and paramilitary activities in and against Nicaragua, quote, where human rights are protected by international conventions, that protection takes the form of such arrangements